The development of AI has raised important questions about copyright law. AI is capable of generating creative works such as music, artwork, and literature, which may be subject to copyright protection. At the same time, AI technology raises questions about who should be considered the author or creator of a work. In general, copyright law applies to the expression of ideas, rather than to the ideas themselves. This means that copyright protection can apply to the output generated by an AI system if it meets the threshold of originality. However, the question of who should be considered the author or creator of a work generated by AI is more complex. In some cases, the user who trained or programmed the AI system may be considered the author of the resulting work. In other cases, the AI system itself may be considered the author. There is currently no clear consensus on how to address this issue, and it may vary depending on the specific circumstances of each case. Some countries, such as the United States, have introduced bills or proposals to address the issue of AI-generated works and their copyright status. For example, the Copyright Alternative in Small Claims Enforcement (CASE) Act, which was signed into law in the U.S. in 2020, allows for small claims copyright disputes to be heard by a tribunal and includes provisions related to the registration and enforcement of copyright in works generated by AI. Overall, the intersection of AI and copyright law is a complex and evolving area, and it is likely to continue to be the subject of debate and discussion in the coming years. In addition to the question of authorship, there are also other important issues related to AI and copyright law, such as the use of copyrighted materials to train AI systems and the potential impact of AI-generated works on existing markets and industries. One issue that has arisen is the use of copyrighted materials to train AI systems. Many AI systems rely on large datasets of existing works to learn and generate new content. However, the use of copyrighted materials for this purpose may infringe on the copyright holder's exclusive rights to reproduce and distribute their work. Some argue that such use should be considered fair use, while others believe that it should require permission or licensing from the copyright holder. Another concern is the potential impact of AI-generated works on existing markets and industries. For example, the use of AI to generate music or artwork could disrupt traditional creative industries and change the way that works are produced and consumed. This could lead to legal and economic challenges for copyright holders, as well as for those who rely on traditional methods of creating and distributing creative works. To address these and other issues related to AI and copyright law, lawmakers and stakeholders will need to consider the evolving landscape of AI technology and its potential impacts on creative industries. One potential solution to the challenges posed by AI and copyright law is the development of new legal frameworks and standards that take into account the unique characteristics of AI-generated works. For example, some have proposed the creation of a new category of intellectual property rights specifically for works generated by AI, which could help clarify the ownership and licensing requirements for such works. Another potential solution is to develop ethical guidelines and best practices for the use of AI in creative fields. This could include principles related to transparency and accountability in the use of AI, as well as guidelines for obtaining informed consent from users whose data is being used to train AI systems. Ultimately, the intersection of AI and copyright law raises complex and important questions about the future of creative industries and the role of intellectual property in an era of rapid technological change. It will be important for lawmakers, stakeholders, and society as a whole to engage in ongoing dialogue and debate to ensure that copyright law remains relevant and effective in the face of new technological developments. Another area of concern related to AI and copyright law is the potential for AI-generated works to infringe on existing copyrighted material. For example, an AI system may generate content that is similar or identical to existing copyrighted works, potentially leading to claims of infringement. This raises questions about the legal liability of the creators of AI systems and the need for safeguards to prevent infringement. To address this issue, some have proposed the use of technical solutions such as digital watermarks or other identifiers to help distinguish between AI-generated works and existing copyrighted material. Others have suggested the use of AI systems to detect and prevent copyright infringement, such as through the use of automated content recognition tools. Another related issue is the potential for AI systems to be used to circumvent copyright protections. such as through the use of automated tools to remove digital rights management, DRM, or other anti-piracy measures. This raises questions about the legal liability of those who develop and distribute such tools, as well as the need for new forms of protection and enforcement to prevent infringement. Overall, the intersection of AI and copyright law is a complex and rapidly evolving area, with important implications for the future of creative industries and intellectual property rights. As AI technology continues to advance, it will be important for lawmakers and stakeholders to stay informed and engaged in ongoing dialogue to ensure that copyright law remains relevant and effective in the digital age. Another important issue related to AI and copyright law is the potential for bias or discrimination in AI-generated works. AI systems rely on large datasets to learn and make predictions, which can lead to bias or discrimination if the data used is not representative or is based on existing stereotypes or prejudices. This is particularly relevant in creative fields such as music or art, where AI-generated works may reflect and perpetuate biases and stereotypes present in the training data. For example, an AI-generated music playlist may inadvertently exclude certain genres or artists based on biases in the training data. To address this issue, some have proposed the development of ethical standards and guidelines for the use of AI in creative fields, with a particular focus on issues of bias and discrimination. This could include principles such as diversity and inclusion in the training data, as well as transparency and accountability in the use of AI systems. Another related issue is the potential for AI-generated works to have unintended consequences or negative impacts on society, such as by perpetuating harmful stereotypes or reinforcing existing power structures. This raises questions about the ethical responsibilities of those who create and distribute AI-generated works, as well as the need for ongoing dialogue and engagement with stakeholders to ensure that AI is used in ways that benefit society as a whole. Overall, the intersection of AI and copyright law raises complex and important questions about the role of creativity, innovation, and ethics in the digital age. As AI technology continues to evolve and impact creative industries, it will be important for stakeholders to stay informed and engaged in ongoing dialogue to ensure that AI is used in ways that promote diversity, inclusion, and social justice. Another important issue related to AI and copyright law is the potential for AI-generated works to create new forms of competition and disruption in creative industries. AI-generated works have the potential to challenge traditional models of creativity and distribution, potentially leading to new business models and revenue streams. For example, AI-generated music or artwork may be sold directly to consumers or licensed to other businesses, creating new opportunities for artists and creators. However, this could also lead to increased competition and disruption for traditional creative industries, potentially leading to legal and economic challenges for copyright holders and other stakeholders. To address this issue, some have proposed the development of new business models and licensing structures that take into account the unique characteristics of AI-generated works. This could include new forms of revenue sharing or licensing agreements that reflect the contributions of both AI systems and human creators. Another related issue is the potential for AI-generated works to create new forms of cultural expression and identity. As AI technology continues to evolve, it may be possible to create works that reflect the unique cultural perspectives and experiences of diverse communities, potentially leading to new forms of creative expression and cultural exchange. Overall, the intersection of AI and copyright law raises complex and important questions about the future of creative industries and the role of intellectual property in an era of rapid technological change. As AI technology continues to advance, it will be important for lawmakers and stakeholders to stay informed and engaged in ongoing dialogue to ensure that copyright law remains relevant and effective in promoting innovation, creativity, and social progress. Another important issue related to AI and copyright law is the potential for AI-generated works to challenge the concept of authorship and ownership of creative works. AI systems can generate works that are complex and sophisticated, leading to questions about the role of human creativity and the contribution of AI systems in the creative process. For example, an AI-generated work may involve the use of algorithms, datasets, and other inputs that are created and owned by multiple individuals or organizations, raising questions about who holds the copyright for the resulting work. Similarly, the use of AI in the creative process may blur the lines between human and machine creativity, leading to debates about the nature of authorship and the extent to which AI systems can be considered creative agents. To address this issue, some have proposed the development of new legal frameworks and standards that take into account the unique characteristics of AI-generated works. This could include new definitions of authorship and ownership that reflect the contributions of both human and machine creators, as well as new forms of licensing and revenue sharing that reflect the complex and collaborative nature of AI-generated works. Another related issue is the potential for AI systems to enhance the creative abilities of human creators, potentially leading to new forms of collaboration and innovation. AI systems can be used to automate routine tasks or provide new insights and inspiration, allowing human creators to focus on more complex and creative aspects of the creative process. Overall, the intersection of AI and copyright law raises complex and important questions about the nature of creativity, innovation, and ownership in the digital age. As AI technology continues to advance and impact creative industries, it will be important for lawmakers and stakeholders to stay informed and engaged in ongoing dialogue to ensure that copyright law remains relevant and effective in promoting creativity, innovation, and social progress.